Yet courts have found that it is a complete defense to a claim under 512F if the party issuing a takedown notice had a subjective good faith belief. What does it say right here? Subjective good faith belief that the use in question was not authorized. Stern v. Lavender, 319F Sup, SDNY, citing, what does it say right here? Citing Matt Haas versus h3h3, Hoshienjada, whatever, how do you pronounce that, versus Klein. So SDNY 2017, which was then citing Lentz v. Universal. So in case you ever wondered whatever happened to the H3H3 case, it is now legal precedent and being cited in other districts as such. So I have one more story for you. It is 13 pages long, but this one's double spaced. This is in a district court. I think this will help clarify what happens in some copyright disputes. When you have a copyright dispute on YouTube and either you file a claim against someone else and then they file a counter notice and then YouTube says you have to go to court, what happens with all that? We're going to read a story about a dispute where one of the claimants was more or less clearly in the right, but still sort of, I don't want to say they messed up the procedure. It's more that the case got messed up because the procedure, they back, you'll see at one point they back off the case and the other person just sort of takes advantage of that. But let's look at this together. This is Shirley Johnson versus the New Destiny Christian Church Center and Paula Michelle White. This does the Christianness or religion has nothing to do with this. This is just a discussion of the legalness. So we're not going to get into any. None of this dispute has to do with the religious part. So it's all going to be copyright and legal stuff here. Before the court is defendant's motion for summary judgment, plaintiff's response, and defendant's reply. To be very clear here, the New Destiny Christian Center Church and Paula Michelle White are defendants. They were earlier plaintiffs, so we're going to be very careful about how we refer to them here. The Paula Michelle White and NDCC are defendants. The defendants made a motion for summary judgment. Plaintiff responded, defendants replied. The court grants defendant's motion for summary judgment, as in favor of our defendants here. Brandon, when you edit this, if you could just put this text like over here or something, I don't know if you can't see you can't see that. If you could put it underneath my picture there so that we know who defendant and plaintiff are. That's going to be hard to keep track of in this case. This action centers on a series of takedown notices in 2012-2013 directed to videos on plaintiff's YouTube channel and whether defendants wrongfully sought to remove plaintiff's videos for containing their copyrighted material. So once again, to be clear, plaintiff's videos were removed by defendant. Defendants are being sued by plaintiff for the alleged wrongful DMCA takedown notices, basically. Plaintiff operates a website, Plaintiff, and YouTube channel where she posts videos that include self-recorded portions of the defendant's sermons. I'm assuming defendant Paula Michelle White is a pastor or priest or something and records her sermons. At all relevant times, these sermons were distributed online and on television by the entity Paula White Ministries. After PWM, Paula White Ministries, discovered plaintiff's YouTube channel and videos containing PWM's intellectual property, PWM set out to determine whether the use was infringing. To that end, this is very important, PWM's then general manager, Bradley Knight, viewed videos posted by plaintiff and evaluated for himself whether they constituted fair use. By January 2012, Mr. Knight formed a good faith belief, their assertion, that her uses were not fair uses as she violated 3 of the 4 tenets. Yes, I realize this is a quote. I'm not getting down on them, but it's tenets, Tenets, of fair use. Mr. Knight then consulted with one of PWM's attorneys to determine what next steps could be taken, as PWM had not obtained copyright registrations on the videos at that time. And we just learned you need them, right? Mr. Knight learned that PWM didn't need to obtain copyright registration to send a takedown notification, true, to YouTube under the DMCA, so he directed PWM employee Antonio Taylor to submit a series of takedown notices on behalf of PWM referencing plaintiff's videos to YouTube. Mr. Taylor submitted the request January 30th, 2012. YouTube responded by asking for more information. PWM responded by sending a cease and desist letter of kinds. On February 2nd, YouTube removed the content February 6th. YouTube notified plaintiff February 6th that her channel was terminated. She responded by writing YouTube a letter asserting that her videos were for non-profit educational purposes in accordance with the doctrine of fair use, which, as we know, the purpose and character of the use is 1, the market usurpation is 4, the amount and substantiality of the portion used is 3, and the non-profit educational purpose is 2. It is only one of 4, and you need a balancing of all 4, not just one is not dispositive of all 4, at least not without some seriously strong evidence, testimony, argument in favor of it. She asked that her channel and 37 videos be restored. The restoration process took several months, but her videos were put back up in May of 2012. Later in June of 2012, PWM registered the copyright for Paula White Ministries Sermons 2010-2011. After this initial series of takedown notifications, Mr. Knight started consulting with attorney Thomas Sadaka at Najami or Najame, I can't tell you, law about plaintiff's use of the intellectual property. Mr. Knight provided Mr. Sadaka a materials list to determine if there was a reasonable basis for a copyright infringement claim. Nothing happened right away, but sometime in 2013, Mr. Sadaka sent a takedown notification to YouTube for one of plaintiff's videos. Plaintiff submitted a counter notification, so YouTube told Mr. Sadaka he had 10 days to notify that he had filed an action, a lawsuit, containing a court order or seeking a court order to restrain the counter notifier's allegedly infringing activity. As Mr. Sadaka did not act within those 10 days, YouTube told him they could no longer provide assistance and he would need to sort things out directly. Then, March 27th, 2014, like 2 years later, Mr. Sadaka, on behalf of PWM, initiated suit. See Paula White Ministries v. Shirley Johnson. See what I meant? That's now it's Paula White's plaintiff and Shirley's the defendant. But we're going to keep referring to them as their defendant and plaintiff in this case. So Paula White is defendant and Shirley Johnson is plaintiff. Just that's what's going on here. Following this, Mr. Sadaka sent YouTube a copy of the complaint, requested it take down the infringing videos. It took no action. He followed up. Again, on April 29th, plaintiff's videos totaling 76 at this time. YouTube disabled the videos on May 2nd. We're like 2.5 years into this. Plaintiff sent a counter notification, yet because of the lawsuit, YouTube sent plaintiff an email June 4th, another month later, that it could not restore plaintiff's videos. That's Shirley Johnson's videos. Later that month, Mr. Knight, defendant's side, noticed another video on plaintiff's channel that he believed to be infringing, so sent YouTube another takedown notification. YouTube responded by asking follow-up questions regarding the fair use factors. He replied by maintaining the video was not protected by fair use. They removed it July 1st, 2014, because this was the third notification YouTube had received alleging copyright infringement. YouTube terminated plaintiff's account. Meanwhile, after the copyright action progressed for a while, PWM decided to voluntarily dismiss its claims. Mistake 2. Although I guess that's probably mistake 1, really, when the first mistake was just using tenants the wrong way. After the copyright action concluded, plaintiff notified YouTube and it restored her channel and videos February 10th, 2015. 3 years into this. That same month, Mr. Knight reviewed another video that plaintiff had recently posted. He asked for guidance on whether the video was infringing from another Najami or Najame law attorney. There's probably some third pronunciation I haven't even thought of. After Vanessa Braley reviewed the video, she submitted a takedown notification to YouTube. YouTube took down the video. Plaintiff sent a counter notification April 22nd, 2015. The video was restored. A final takedown notification was sent around May 20th, 2015. Prior to sending the request, Mr. Knight had reviewed the video. There's a reason why we're saying all this. Considered the fair use factors and formed a good faith belief that plaintiff's use of PWM's material was not fair use. Plaintiff sent a counter notification. YouTube restored the video June 5th, 2015. So 3.5 years into this. After all of this, plaintiff, proceeding pro se, unrepresented, initiated this suit against defendants and 2 other entities for malicious prosecution based on the copyright action of October 8th, 2015. In her ad damnum, I don't even know what ad damnum means. In a clause of her third amended complaint, plaintiff requested economic, non-economic, and nominal damages pursuant to 17 U.S.C. 512F, which is the section about copyright takedown notice misrepresentations. She also alleged a violation of her rights under the First Amendment to the U.S. Constitution. Okay, quick note, that's only against governments. By filing the copyright action and making numerous false copyright infringement complaints to YouTube, which caused the removal of videos from her channel. March 23rd, 2017, the court dismissed plaintiff's purported federal claims under 512F and the First Amended complaint without prejudice, which means they can be filed again, but denied her leave to file a Fourth Amended complaint due to the late stage of the proceedings and the court's belief that she had just intended to assert a claim for malicious prosecution. So, plaintiff filed this case again, pro se, bringing claims for material misrepresentation under 17 U.S.C. 512F and abuse of process. After the court whittled down plaintiff's bases for these claims, the case has proceeded on plaintiff's 512F misrepresentation claim as to the takedown notices and the abuse of process claim based on plaintiff's allegation that defendants continued the copyright action to procure the deletion of plaintiff's YouTube channel. Now, defendants have moved for summary judgment. Briefing is complete. The matter is ripe for summary judgment. So, quick summary. The defendants in this case right now, Paula White Ministries, they have sermons, they record them, they post them on YouTube, and Shirley Johnson posts what Shirley Johnson thinks are fair use clips and what PWM thinks are not fair use clips. Does this sound familiar? This situation happens a lot. And I often counsel clients to file this kind of lawsuit and have this kind of dispute. Is there any wonder why they don't want to? Summary judgment is appropriate only if the movant shows that there is no genuine dispute as to any material fact and that the movant is entitled to judgment as a matter of law. What the heck is this? This is the summary judgment legal standard. This is part of it. So this, in the sort of table of contents of the case, we've gone over sort of the history of how we got here. Now the court's going over the more or less, not the history of the law, but it's going over the applicable law as summarized up to now, so that we know when we read the next part of the case, the analysis, that we will be applying this legal standard. I'm going to go quickly through this. The point of summary judgment is to avoid going to trial. Right now, we're right before trial, generally speaking. There's exceptions. But right now, in this case, we are before trial. We're not going to trial because the court did resolve the matter on summary judgment. Summary judgment is basically where you present all of the things you would present in a trial, but you present them in papers, in writing, depositions on the record before the summary judgment motion, and then you cite to those things in the summary judgment motion. And if the court agrees, we'll see. If the movant shows that there's no genuine dispute as to any material fact, that the movant is entitled to judgment as a matter of law as well, then summary judgment is appropriate. So, as to issues for which the movant would bear the burden of proof at trial, the movant must affirmatively show the absence of a genuine issue of material fact or relevant fact, and support its motion with credible evidence demonstrating that no reasonable jury could find for the non-moving party on all the essential elements of its case. Now remember, a jury is on a fact-finding mission. A jury is not to determine the law. The jury is to determine which facts are true and which facts are not true. So what we're talking about here are if there's no way that a fact would be in dispute in front of a jury, then we can assume that we can make that decision instead of a jury. That's simplified. As to issues for which the non-movant would bear the burden of proof at trial, the movant has two options. The movant may simply point out an absence of evidence to support the non-moving party's case, or the movant may provide affirming evidence demonstrating that the non-moving party will be unable to prove the case at trial. The burden shifts to the non-moving party, who must go beyond the pleadings and present affirmative evidence to show a genuine issue of material fact exists. So remember, it's not the non-moving party's choice, or they're not trying to win the whole case here. They're trying to show that there are still issues to go to trial with. That's it. That there is a genuition, new word, everybody, genuition. That there is a genuine issue of material fact for trial before a jury. The court must view the evidence and all reasonable inferences drawn from the evidence in the light most favorable to the non-moving party, the responding party, the victim of the motion for summary judgment. However, a court need not permit a case to go to a jury when the inferences that are drawn from the evidence and upon the non-movement replies are implausible. Discussion. As it stands, plaintiff's claims rest on the same underlying issues, legitimacy of the takedown notices PWM sent to YouTube between 2012 and 2015. Plaintiff maintains that these notices were false. Remember, plaintiff is Shirley Johnson, the YouTube channel that got taken down. Plaintiff maintains that these notices were false from the start based on her contention that PWM and its attorneys did not have a subjective good faith belief when they contacted YouTube to remove plaintiff's videos. This is part of 17 U.S.C. 512F, the misrepresentation section of copyright law. If I issue a takedown notice for your video and I don't have a subjective good faith belief that you were infringing upon my copyright, which includes processing fair use, Lens Fee Universal, then you have a 17 U.S.C. 512F misrepresentation claim against me for whatever action you need to do to get that resolved. If you were injured and you lost profits, if you had to hire an attorney, any of those costs that we just talked about in the enumerated sections, you could get at through 17 U.S.C. 512F. That's what Shirley Johnson is trying to do here. Yet defendants move for summary judgment based on the record evidence that the takedown notices and copyright action were founded on defendants' subjective good faith belief that the plaintiff's videos infringed their copyrighted material. With this, defendants claim that both plaintiffs' 512F and abuse of process claims fail. In turn, plaintiff argues that the defendant's one-sided evidence should be rejected and summary judgment granted in her favor. On review, the court agrees with defendants. The DMCA sets forth a detailed process allowing a copyright owner to observe infringing content on a website like YouTube and then have the content taken down. Section 512C3A outlines the process for submitting a takedown notice. To be effective, it must include a notice, physical signature, or electronic signature, identification of the work, and this all has requirements. If you meet these, it's a valid takedown notice. Abusing this takedown process may subject an individual to liability under Section 512F. This is very important. Listen up. Any person who knowingly, materially misrepresents under this section, 1, that material or activity is infringing, or 2, that material or activity was removed or disabled by mistake or misidentification shall be liable for any damages as the result of the service provider relying upon such misrepresentation in removing or disabling access to the material or activity claimed to be infringing, or in replacing the removed material or ceasing to disable access to it. Yet courts have found that it is a complete defense to a claim under 512F that the party issuing a takedown notice had a subjective good faith belief that the use in question was not authorized. What in the world is a subjective good faith belief? Well, let's break it down. Objective versus subjective. Objective means that something is more or less outwardly agreeable upon its qualities and features, objectively a good job on something. Everybody would agree, everybody would look at it and you could see, okay, your job was to put that nail, through that board and you did a good job. Subjective would be more or less any one individual's opinion on the thing. And in this case, we are modifying the subjective individual's opinion with good faith, meaning that they've tried hard and sincerely in some way. And so this is not just a statement. You don't just say, I have a subjective good faith belief. No, you have to prove that you came to some kind of individualized, not just a general view and not necessarily the correct view, but that you came to an individualized view and that it was properly informed and that you made the best decision you could under the circumstances. This is very important, and you'll see why. Citing Lentz v. Universal, the U.S. Court of Appeals for the Ninth Circuit held that a copyright holder must consider fair use before sending a takedown notification, and if the copyright holder forms a subjective good faith belief that allegedly infringing material does not constitute fair use, the court is in no position to dispute the copyright holder's belief, even if it would have reached the opposite conclusion. Even if the court would have reached the opposite conclusion, the copyright holder could still be wrong and still win the case. I have literally litigated and won on this issue in a case. I don't really like to bring up my past cases and parade them around like that because I like my client's privacy and all that. But we had a case in the Eastern District of Pennsylvania where two people had this exact kind of dispute. One person had made a YouTube video. Another person had copied parts of it. It was kind of a Matt Haas v. h3h3 Productions kind of thing, where there was a takedown notice, and the question is, was it a legitimate takedown notice or not? In Matt Haas's case, it was not a legitimate takedown notice. In this case, we haven't even gotten to the part of whether it's a legitimate takedown notice. The question isn't whether it was legitimate. The question is whether it was a misrepresentation. Misrepresentation in a knowing or willful or should have known, which translates to, thanks to Lentz v. Universal, a subjective good faith belief. If summary judgment should be denied, of course, if the copyright holder simply pays lip service to the consideration of fair use by claiming it formed a good faith belief where there is no evidence. The evidence before the court, however, uniformly supports defendant's good faith defense. Critically here, plaintiff has not supplied any evidence on a factual basis on which to find the opposite. Defendants, in pursuing takedown notifications, would have had to have made a knowing material misrepresentation. As it stands, defendants' affidavits supply that before PWM sent takedown requests, plaintiffs' videos were analyzed to determine whether they constituted fair use. Both Mr. Knight, Mr. Sadaka, Ms. Braley evaluated this. Each time PWM concluded that plaintiffs' videos did not constitute fair use and were infringing, PWM's correspondence with YouTube confirms this, as does the 2014 copyright action. Plaintiff retorts by offering her version of events, which the court finds are based exclusively on speculation. Although plaintiff claims certain inaccuracies in PWM's submission to YouTube, she has not come forth with competent summary judgment evidence that calls into question PWM's good faith belief. So in other words, you can't just say, oh, they didn't have a good faith belief. You have to present some kind of evidence. So conduct a deposition, ask some questions, find out what they did to form a good faith belief. Although plaintiff claims certain inaccuracies, she has not come forward with evidence. Even if PWM acted unreasonably and made an unknowing mistake in its submission, plaintiff has not presented evidence that tends to demonstrate some knowing misrepresentation on their part. Thus, the court finds that PWM sending of takedown notices did not evidence a bad faith or entail the making of a material misrepresentation. That same goes for plaintiff's abuse of process claim. For this claim, plaintiff alleges that defendants continue the copyright action to obtain the permanent termination of plaintiff's YouTube channel and to intimidate, punish, shame, harass, attempt to extort millions of dollars from plaintiff. Putting aside defendant's argument that this claim is preempted, the court finds that the undisputed record evidence belies plaintiff's assertions. Abusive process has three elements. The defendant made an illegal, improper, or perverted use of process. Defendant had ulterior motives, and plaintiff suffered damage. The plaintiff must prove that the process was used for an immediate purpose other than that for which it was designed. Where the process was used to accomplish the result for which it was intended, regardless of an incidental or concurrent motive of spite or ulterior purpose, there is no abusive process. As the record reflects, PWM held a subjective good faith belief that plaintiff's videos were infringing its copyrighted materials. This belief led PWM to submit takedown notifications to YouTube concerning plaintiff's videos, and when those proved futile, PWM initiated the copyright action. The goal of the copyright action was to stop plaintiff from infringing PWM's copyrights, yet as Mr. Sadaka's affidavit states, after several months of litigation, it became apparent plaintiff was not interested in resolving the case. As such, expensive, protracted litigation was anticipated. Based on these high anticipated costs with little or no expected return, an economic reason was made to discontinue the litigation. Against this backdrop, the court finds no evidence to support that plaintiff's belief that defendant's continuation of the copyright action constituted abuse of process. Rather, defendant's actions were founded in a subjective good faith belief that plaintiff's videos were infringing, which led them to both submit takedown notices and litigate against plaintiff. Thus, plaintiff's abuse of process claim cannot survive summary judgment, and defendant's motion is due to be granted. It is ordered and adjudged as follows. The summary judgment motion from defendant is granted. Judgment in favor of defendants. Terminate other pending motions. Close the file. Done and ordered. Roy Dalton, United States District Judge for the Middle District of Florida. There was an interesting site in here that we missed. He said here, when we were reading the Section 512F claim, in case you missed it here, we're going to zoom in on this. Yet courts have found that it is a complete defense to a claim under 512F if the party issuing a takedown notice had a subjective good faith belief. What does it say right here? Subjective good faith belief that the use in question was not authorized. Stern v. Lavender, 319 F Sup, SDNY, citing, what does it say right here? Citing Matt Haas versus h3h3, Hoshienjada, whatever, how do you pronounce that, versus Klein. So SDNY 2017, which was then citing Lentz v. Universal. So in case you ever wondered whatever happened to the H3H3 case, it is now legal precedent and being cited in other districts as such.
I knew that was going to happen.
Isn't that cool?
It was such a beautifully written opinion too. So I'm happy.
Yeah. It was a clear case. It was a very good opportunity for a precedential opinion. So I could not help but bring you that little bonus case and that little bonus clip there, because that's just so cool that all the work that the Kleins did, the community came together for them as well, donated money. We made videos about it and everyone was following that for a while. In fact, I think that's kind of what launched this channel a little bit. Yes, it was the Fine brothers at first, but H3H3 was next. So let's see. Somebody says, suppose a copyright holder files a DMCA takedown notice for an unregistered work. The content in question is taken down, but the uploader files a counter notice. Upon receiving the counter notice, the copyright holder disagrees with the counter notice and do not want the content restored. According to the DMCA, they must file a lawsuit seeking an injunction. Yes. So the problem that you are anticipating is a live problem. That is a true and correct statement. You will then have the problem of YouTube or the content host in its safe harbor needing to restore the content, but you don't have a registration, so you can't sue and get a preliminary injunction or temporary restraining order. Or if you do that, because there might be somebody who might try, you need to be counting on your defendant, the recipient of this takedown, to not be able to defend themselves in court. So you're going to be walking one of two lines there. You're either going to have to wait for the copyright registration, or you're going to have to take the chance that a defendant won't know to cite this case, or court won't know to bring it up, or court will agree that a restraining order or injunction is warranted, even though. So maybe what you need to do is look up those pre-registration requirements and live requirements and see if you meet those. Otherwise, really got to be filing those copyright registrations as soon as you make your content, as soon as it's fixed in a tangible medium of expression, and I guess publicized. You would need to register it. $35 a pop. That's just what it is. Yeah. So on the EU directives issue, there's some talk that it's being railroaded through because the attempt will then be to create global copyright law that follows these new EU directives. That's one of the things I'm concerned about. Thank you to our Patreon supporters at the $50 level in the month of March. Thank you for Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Chris, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Aspernari. And thank you to the 170 plus $5 plus supporters scrolling on the LED panel behind me. And I'm sure that Brandon will put you in the crawl. I'll give him some dog video to insert here as we take the thing out. I love you all. Thank you for joining me, and I'll see you in the next videos. Bye. Yeah, oh, she's, yeah.